Hi, my name is Lydia, and I'm an immigration attorney.
Today we will discuss asylum and whether you're eligible to seek asylum status here in the US. Asylum refers to the protection granted by a country to foreign nationals who have fled their own country due to fear of persecution. In asylum cases, persecution refers to the harm or suffering inflicted on an individual as a punishment for having a belief or characteristic that the person causing the harm dislikes and regards as offensive. When someone seeks asylum, they're essentially requesting legal protection and the right to remain in another country because they fear returning to their home country. To seek asylum in the US, you must have suffered persecution or fear that you will suffer persecution due to either race, religion, nationality, membership in a particular social group, or political opinion. If you can prove that you have suffered past persecution, or you have a well founded fear of persecution based on at least one of those 5 grounds, you may qualify for asylum protection. In the event that you have not suffered past persecution, but you have fear that you will suffer persecution in the future if sent back to your home country, you need to establish well founded fear. So, what is well founded fear? That can be established by showing that you have both a subjective fear of persecution and that fear has an objective basis. That means you must be able to show a genuine fear of return, and that fear is based on facts that will lead a reasonable person in similar circumstances to also fear persecution. There are 2 other requirements. 1, you are not a US citizen, and 2, you are either physically present in the US or at a port of entry. This is the key difference between someone who is given asylum status versus refugee status. A refugee is someone who is located outside of the US at the time of seeking protection, whereas someone seeking asylum is already here. Regardless of your immigration status, you may apply for asylum within 1 year of your arrival to the US. However, you may qualify for an exception if you show a changed circumstance materially affecting your asylum eligibility or extraordinary circumstances relating to your delay in filing. Examples of changed circumstances that materially affect your asylum eligibility include changes in conditions in your home country, and if you were listed as a dependent in someone else's asylum application, but you lost your relationship to the main applicant because of marriage, divorce, the main applicant's death, or by you turning 21 years old. Examples of extraordinary circumstances include having a serious illness or mental or physical disability. You could also argue ineffective assistance of counsel by detailing in an affidavit the agreement and the accusations against that attorney. You may also qualify for other exceptions, so you'll want to seek the help of an attorney.
Here's what the application process looks like for asylum. There are 2 different types of application: affirmative or defensive. Affirmative asylum generally means that you are not in removal proceedings. Either you have not been issued an A number, or you are issued an A number, but you are not currently in EOIR proceedings, which stands for Executive Office for Immigration Review. Note that just because you received a notice to appear with an A number does not automatically mean you are in removal proceedings. In this case, you can apply for affirmative asylum by filing Form I-589 with USCIS. On the instructions of the form, you will see a list of documents that USCIS requires you to submit with the form. And this includes, but is not limited to, your passport, travel documents, identification of documents, evidence supporting your claim on the conditions of your country and your fear of persecution. Once USCIS receives your application, you will be issued a receipt notice, as well as a notice for a scheduled biometrics appointment where they will take a picture of you and take your fingerprints. Asylum applications take many months to be processed, but once USCIS is ready to interview you, they will send you an interview notice, which is your opportunity to go in person to prove to the asylum officer that you are indeed eligible for asylum. On the other hand, defensive asylum is when you are already in removal proceedings. You will need to file the same form, I-589, and submit the required supporting documents. However, it must be filed with the immigration court at the EOIR and not USCIS. If the judge determines you are eligible for asylum, you will be granted asylee status. If the judge finds you ineligible, the judge may determine whether you meet the criteria for any other forms of relief. Whether you need to apply for asylum affirmatively or defensively, it's a long and complex process, so it's highly important that you seek the assistance of an experienced immigration attorney. I hope this helps you. I hope you have a good day.